Okay, good evening, everyone, and welcome to our webinar on vaccine cohort post-pandemic. I'd like to start with a quick disclaimer. Any opinion expressed today by me are my own and do not represent views of my employer. We are incredibly fortunate to have an outstanding panel of speakers today, all of whom are true experts in very specialized field of law. Our first speaker is Chief Special Master Brian Corcoran, who will present on the Office of Special Masters and adjudication of Federal Vaccine Act claims. Following that presentation, we'll hear from Professor Brian Abramson from Florida International College of Law, who will discuss vaccine injury compensation beyond the National Vaccine Injury Compensation Program. Next, we'll have my friend and a former classmate, attorney Jennifer Allen, who specializes in personal injury, including vaccine injury. And finally, a brilliant attorney, Jessica Wallace from Siri and Glimstad, who will provide insights from petitioner's perspective. After all presentation, we have set aside a time for Q&A. Please feel free to post your questions in the Q&A chat below, and we'll do our best to address as many as possible. I also would like to take a quick moment and thank our former chair of Law and Science Committee, Martha Del Signore, for organizing this event and putting this fantastic panel together. And now I'd like to turn over to Chief Special Master Brian Corcoran.
Okay, hello everyone. Thank you, Irene. So I'm going to start things off by talking a little bit about the Office of Special Masters, which is the place that most vaccine injury, if not all, but there's a few claims outside, but most vaccine injury claims in the United States would be litigated. And it's here in Washington, D.C. So I have some slides prepared, and we're going to put them up now, hopefully, and then I will use them to narrate. Okay, here we go. So we'll go to the second slide. So the vaccine program, as we often refer to it here, was created in the 1980s, in 1986. And we call it the Vaccine Act, but as you can see, this is the full site for it if you want to look at it. The Vaccine Act came into being because pharmaceutical companies who manufactured vaccines were starting to be sued based upon claims that the vaccines were causing injuries. And they threatened to stop making vaccines if the lawsuits didn't go away. And then there were some individuals on the Hill and some judicial personnel who got together and said, well, we ought to create a sort of some kind of program to resolve these claims. And the thinking was that the program was going to sort of respond to the problem, you know, one time. It might last a couple of years. The vaccines at issue would get fixed and the problem would go away. And here we are 30 plus years later, and we're alive and kicking, and we've never been busier than we have been in the past 10 years. So best intentions didn't quite work out. All of the monies that we pay for damages, plus our own costs of running the Office of Special Masters and fees, come out of what's called the Vaccine Fund, which is created by a small tax that pharmaceutical companies place on every covered vaccine that's administered in the United States. It goes into a big bucket. There's over $4 billion in that fund. So there's plenty of money for us to satisfy damages, pay the costs of the court, and pay the lawyers who represent people in our court. And the Office of Special Masters, OSM, which I am responsible for, is the judicial entity that decides these cases. Okay, next slide. So we have our own sort of process we've created, some of which stems from the Act and some of which comes from our thinking about how to adjudicate these claims that we utilize. These days, when a new claim is filed, first thing happens is, back to slide 3, perhaps. Anyway, there it is. Okay. So we go through pre-assignment review, where we look at a claim and we try to assess, have sufficient materials been filed in order to evaluate the claim? Is there proof of vaccination? Are the medical records filed? These are all things we need to see for the government to resolve the claim. And I'll talk a little bit about the government's role. We also have a component of OSM, more acronyms, there's too many as far as I'm concerned, called SPU, the Special Processing Unit. It attempts to resolve cases we think should settle. And it's been around now for 10 years. It's pretty successful, I would say. And approximately half to almost 2/3, it's more of a half these days, of all the claims that are live in our court are in SPU. They tend to be smaller claims like CIRVA injuries, shoulder injuries. We have, as of this month, the number might change at the end of the fiscal year, but there's a little more than 3,500 active cases. And I'll also add our cases, while we are adjudicating them, are not open to the public. The public cannot listen to our trials. They can't access the filings. Until we issue a decision for the public, we keep the materials that are filed in our cases and the medical records private. Okay, next slide. So the judges who decide our cases are called special masters. And it's really a misnomer. I think, again, it's an artifact of when the act was created and the thinking that, like special masters, which can be appointed by district courts for small matters, the thinking was, well, these individuals will be appointed by the court. They'll address these claims. They'll give advice to the judges on our court at the Court of Federal Claims, and they'll go away. And now we do much more than that. We kind of perform a little bit of a judicial function. We perform a mediative function where we try to help settle cases. And then we do a lot of calculation of damages and attorney's fees. So we're looking at both whether causation is established, and then in the back end, we look at how much damages have been proven. And then at the very end, we decide how much fees an attorney should collect for their work on a case. We control discovery in our cases. Any effort or desire to take a deposition or get information has to pass through us first. We have to approve it. And finally, we're often referred to sometimes in some decisions as inquisitors, meaning we attempt to push cases in the right direction based on our experience adjudicating these cases. So if I get a case that I think should settle, because I've seen a lot like it, and I know the petitioner is going to win, I tell that to the parties, and I try to get the case in a position where that will happen. And the opposite is true if I get a claim that I've rejected repeatedly. I try to get the case dismissed. Okay, continue. So there are a couple of prerequisites before you can bring a claim in the vaccine program. First off, the vaccine has to have been defined as a covered vaccine. There are many vaccines that people get that are not covered, like the yellow fever vaccine. There are even different versions of vaccines that aren't covered. So there's two versions of the pneumococcal vaccine in the United States that people get. One is approved for children. One is only approved for adults. And by and large, the only kinds of vaccines that are covered are those approved for children. So if adults get a vaccine that's approved for children, they can bring a claim. And I will add, by the way, right now, today, 80% of our claims are brought by adults. So again, another artifact of the past. It was thought that the vaccine program would only cover injuries to children. That's why the vaccine compensation program has the name it has, but we see far more adults than children. Claimants have to prove that they received the vaccine. So sometimes that's an issue. Did they actually get a vaccine or not? They can prove it with other evidence. And then they have to prove an injury. And there's a 3-year, 36-month limitations period. It runs from the onset of the injury, whether or not the injured party was aware that they were injured. So that's sometimes, sometimes people will come into the program and they'll say, well, I was diagnosed with a particular disease on this date, but the onset might precede it by several months. And finally, there's a severity requirement that applies to all claims where you have to prove some sequelae or symptoms from your injury that last 6 months from the onset. Most of the time that's easy to satisfy, but there are cases that are dismissed because it turns out that the individual was largely better within 6 months. Okay. So there are two kinds of claims in the vaccine program, table and non-table. Table claims were originally thought to be what we would be doing all the time. In a table case, essentially it's a chart that litigants can see, and individuals who want to bring claims can see it too. Causation's presumed, so we don't even get into can the vaccine cause the injury. The government has essentially conceded in such a case that causation is likely or there's enough evidence to support it. So essentially all you have to prove in a causation case is that you got a covered vaccine, that you meet the requirements as established in the regulations to prove the injury, and that the injury or the disease occurred in a medically acceptable time frame as defined by the table. There's some regs that define each of the table injuries and talks very specifically about what their elements are. There's also a look back component where if the table is amended to add a new claim, let's say a new vaccine, like if the COVID-19 vaccine is ever added, there's a provision that allows claims that would have been untimely to be saved, and they can be filed, up to 6 to 8 years after the vaccination event or the injury. Okay, next slide. The other kind of claim is a causation in fact claim. And these days, I would say, we kind of shift back and forth, but we're kind of at half and half now. So we had a period where most of our claims were causation. Now it's about 50% causation, 50% table. There's a Federal Circuit case called Alton. It controls the legal standard. It defined the legal standard that we applied, and I'll talk about in a second. There's also a causation claim that involves significant aggravation. So if an individual comes to the program, they say, I had a disease before I got here, but I got these vaccines and they made it worse. They have to argue significant aggravation. The elements are pretty similar. The significant aggravation claim incorporates Alton and adds a couple other requirements. Okay, now I'll talk a little bit about the Alton prongs. So there are three things that you have to prove under Alton. It's a three-prong test, and you must prove all three to prevail in the vaccine program. So if you fail on one, the claim cannot survive. First is what I would call can cause, or sometimes people refer to it as general causation. You have to establish some kind of medical explanation or scientific theory for how the vaccine could cause the injury at issue. You have to offer reliable evidence and a reliable theory. And we sort of take note of the Daubert standards for evidence, for scientific evidence. We don't limit any proof in the vaccine program. Everything comes in, everything. But we do think about Daubert quite a bit, and we use it to analyze the reliability of the evidence. I'll also note, and this is something that's been a little bit debated in the program, but from my standpoint, the circuit's been very clear, the Federal Circuit, in establishing that mere plausibility of a theory is not enough. You have a preponderant obligation to show the theory. So you can't just say, well, here's a plausible theory. It's possible the vaccine could cause the injury. It has to be better than that. Second element is did cause. Specific causation, sometimes it's referred to. And that's establishing that there's some sequence that you can explain linking the petitioner, the claimant who says he's injured, to the injury, and that the process matches what you would expect to happen under the initial first prong theory. And we look at a lot of different kinds of evidence. We look at the medical records, we consider treater opinions, those sort of things. Final prong is the time frame. You have to show a medically acceptable time frame between the date of vaccination and the onset. A short onset sometimes can be fatal to a claim. A long onset can be fatal. If you got a vaccine and then said you had onset 3 years after or 2, let's say, and you filed it just in time to avoid the limitations period, likely the claim might be dismissed for time frame. Okay, next. In the vaccine program, we consider a wide array of evidence, and pretty much, the short answer to this question of what evidence do you need to offer, anything is acceptable. We look at everything. We look at medical records, we look at witness statements, we look at testimony of individuals, we consider a lot of expert reports and a lot of expert inputs. That's probably the hardest part of the job. And we review a huge amount of medical and scientific literature involving immunologic questions and biologic questions about diseases. We apply a preponderance standard, which colloquially is sometimes referred to as 50% and a feather. So you just have to cross the 50% line. In a close call case, our general approach here that's been affirmed by the circuit is to give the case to the petitioner. And the special masters are responsible for weighing the evidence and the credibility of the witnesses that we see testify, including experts. It is not something that is to be done on appeal by the judges in our stead. We do it. Okay. Now, as I alluded to earlier, originally the thinking was the program was going to go away. That did not happen. Here we are 30, almost 40 years later, we're still kicking along pretty nicely. We do find that the number of table versus non-table claims fluctuates depending upon what's going on. SERVA claims, which serve as an acronym, it stands for shoulder injury related to vaccine administration. That's a big claim in the program right now. So we have a lot of those kind of table claims. That's a table claim. But what probably keeps the special masters busiest are deciding non-table claims because they're much more, complex and the scientific issues are harder to resolve. One of our greatest moments in the history of OSM was resolving the omnibus autism proceedings. They took, approximately 7 to 8 years to get through. There were 3 very large test cases. It was a 2 or 3 month trial where 3 special masters heard evidence in 3 separate cases at one time. So over time, witnesses and experts came to our court. They presented evidence, and then 3 decisions were written. And they were all affirmed on appeal. And I think we did really good work in resolving those arguments. And I'd also reiterate something I said earlier, which is special masters, we're sort of a quasi-judicial function. We decide the cases ourselves, where they're all bench trials, by the way. We decide them, not a jury. But we have some powers to push cases along and try to get them where they should be. Okay, last slide. A couple of final thoughts for the future. And things that might be interesting to practitioners. One is we have what I would deem probably the best fee shifting statute that anyone has ever seen. We pay prevailing parties their fees. If you win the case, you get reasonable fees. You can't get an unreasonable fee, but you get your money. And we even pay in cases that are unsuccessful, although you have to prove reasonable basis. The special masters sometimes learn particular specific areas of the law and will apply certain, they'll work on a particular kind of injury or claim. And as I think you're going to hear from some of the other panelists today, there's a lot of talk about, will the COVID vaccine come to the program and what will happen? The short answer here for me is I don't know, but we'll be ready to do something about it if it does. Thank you.
Thank you, Honorable Corcoran, for your insightful presentation. And now we'll move to speaker, Professor Brian Abramson, who will be discussing alternative compensations beyond the National Vaccine Injury Compensation Program.
Okay, well, let's start on my slides. They should be the next set. Jonathan. Okay, yes, that is my beyond the NVICP. So let's go to the next slide. So important thing to understand, basically, if you're asserting that you have an injury from an NVICP covered vaccine, you're foreclosed from going to a different tribunal. You can't go to your state court or federal court and file a claim there. It'll just be dismissed because statute requires you to go to the NVICP. But that's not sort of a permanent state of affairs. So if you go to the NVICP and you're unsatisfied with the outcome there, then in theory, you can move to a civil court. You can say, okay, I reject the opinion of the NVICP. I am going to file a civil claim. And there are some twists to that we have seen recently. First, it is sort of exemplified in De Costanza versus GlaxoSmithKline. It's a New York case where a plaintiff is suing and saying basically that the vaccine manufacturers engaged in false advertising and they received this vaccine that it didn't need to receive because they thought it would provide more protection based on the advertising than it actually provides. But it's an NVICP covered vaccine, so they have to go through the program first. So what this plaintiff did was they filed a petition with the NYCBA, and they never filed their medical records. They just asked for delay after delay after delay, for extensions of time to file things. And the rule in the NYCBA is if your claim is not resolved within 240 days after filing, at that point you can withdraw. You can say, well, I'm unsatisfied with the outcome at this point, and then you can go to in civil court. Now, that's not supposed to happen, and it's something that I think the NYCBA is going to be more wary of in the future in terms of saying, well, this is a correctly filed claim that can be dismissed and moved to civil court on motion of the petitioner. But in this case, we went to the Eastern District of New York after that 240-day period, and the Eastern District looked at the proceedings before the special master. So the special master didn't object when the petitioner in that stage sought to exit the program, and this case is therefore allowed to go forward in the Eastern District of New York. Now, I'm going to talk about a different case that presents the same theory, where that theory lost. So it's likely that this isn't going to actually prevail in the district court based on precedents. But this is an example. There's one way that you get to a district court or a court outside the NYCBA, is go through the program, do the sort of the minimum that you need to string it along for 240 days, and then say, okay, I want to withdraw from the program. There is a subsequent case to that, Feders v. HHS, where the CFC denied attorney's fees to counsel. Now, as Special Master Corcoran noted, you get attorney's fees if you basically have a reasonable claim and you press it and it's not frivolous and so forth. But here, it was clear that the attorney was just pursuing the strategy of using this 240 days as a waiting out period before they could say, okay, I'm withdrawing from the program, we're going to move to civil court. And so they weren't allowed to get those attorney's fees. That's at least one knock that you can get. And then we have in re Gardasil products liability litigation. This is this class action that's going on in North Carolina over assertions that Gardasil, which is an HPV vaccine, caused injuries. Several of the plaintiffs in that case had not timely filed claims with the NYCBA. They had not filed claims within the statute of limitations period. They filed claims that were late, that were beyond the statute of limitations period, and therefore they're foreclosed from ever filing civil claims based on injuries related to that vaccination because they didn't get through the NVIC process in a timely manner. And I will add to that, there's sort of a possibility that that kind of reasoning could be applied to plaintiffs who go to the NYCBA and never provide their medical records, which statutorily you are supposed to provide your medical records and other things when you file that claim. That would be something that the special master would have to adjudicate or say something to the effect that this claim was not properly filed, which didn't happen in De Costanza, but if it happened in a future case, you would be in fairly much the same standing as you are in the in re Gardasil case, where okay, you didn't properly go through the NYCBA, therefore you don't have access to civil courts beyond that. It's cut off forever. Next slide, please. Once you get to a civil court on a vaccine injury claim, you would think, well, who can I sue? I can sue the manufacturer, or I'll sue the distributor, or I'll sue the hospital system or the pharmacy where I received the shot. I'll sue the actual administrator of the vaccine. But it's not that easy. So we have a Supreme Court case, Bruce v. Wyeth, very famous case in vaccine injury circles. You would know this. Where Justice Scalia writing the case, and it's also sort of great for this quote that Justice has, where he says that vaccines have been so successful that people have forgotten to be afraid of the diseases that the vaccines prevent, but are now afraid of side effects from the vaccines. But that's dicta. The key point there is that Scalia says that the intent of Congress was that no design defect can be brought against the manufacturers as long as the vaccines are properly labeled. So every vaccine will have a label. It has contraindications and potential side effects, and things that you should know. You shouldn't take the vaccine if you have these situations, and these are potential things that can happen if you take the vaccine. And if you have a properly labeled vaccine, so that the labeling reflects what the manufacturer discovered in the course of clinical trials and things of that sort, then you can't pursue a design defect claim. That's sort of the most common claim that you have in pharmaceutical products, if there's something wrong with the design of the product. So you would have to be able to show that there was some intentional, well, we know this thing is going to cause a harm and we're not putting it on the label sort of thing, which is very difficult to show. Now, that does not protect the administering physician, but we have a couple of cases, and a very few, where these cases have gone through the NYCBA and gotten to other tribunals that have been able to examine them. Hazelhurst v. Hayes, I think is the most prominent of those, with an actual jury trial on a medical malpractice claim where the doctor administered scheduled childhood vaccines, and there was an asserted injury that was alleged to have been caused by the vaccine. And essentially, what the jury found was there was no liability on the part of the doctor. In order to show medical malpractice, you basically have to show that there's a standard of care and that the physician deviated from that standard of care. And in fact, vaccinating children for contagious diseases, for diseases for which childhood vaccines were recommended, is adherence to the standard of care, not deviation from it. Deviation would be not vaccinating children. Also, Hurlth v. Merck was a failure to warn case and fraud-based state law claims case where plaintiffs, having gone through NYCBA and now seeking to pursue a cause of action in federal court, basically argued that, well, they should have a lower burden to show that there was a failure to warn or that there was fraud because of the setup of the NYCBA system. And the court said, no, the NYCBA isn't supposed to make it easier to prevail in a civil court if you get through the NYCBA. It doesn't have that kind of effect at all. It's just a program that's supposed to compensate your injury without you having to get to the civil court. Let's move to the next slide. There's also a learned intermediary doctrine. This is a fairly important doctrine that applies when you're considering the liability of manufacturers. All vaccines are prescription drugs. This is a determination of the FDA. And therefore, you can't get a vaccination unless you have a prescription. Now, some states allow pharmacists to prescribe, but either way, there is someone who is a trained medical professional who's supposed to be evaluating each individual patient and determining this is someone who's suitable to receive this prescription for this drug. And therefore, that's another kind of layer of protection that applies to the manufacturer, that the learned intermediary is the one who's making the determination that this is suitable for the patient to receive. There's one interesting exception to the learned intermediary doctrine, and the LID, as it's called, applies to all pharmaceutical products that are prescription products. And in fact, there's a Florida case that determined that, the more complex kind of the process of administration is, the more protective the learned intermediary doctrine is. So if you require surgery for something, then that's a further step away from the manufacturer of whatever it is to cause the harm. But a vaccine is something that has to be administered by a physician, usually, or administered by a pharmacist. It's not typically something people self-inject, even though it's plausible to do. So it's not like a pill that you take home and take on your own. But there is an exception in this 1995 case of Humphrey v. C.R. Bard that says that there is an exception to the learned intermediary doctrine where vaccines are administered in public mass clinics where there's not a physician involved in individual vaccination. And of course, we had tremendous number of public mass clinics for vaccination for COVID vaccines. So it is kind of an open question as to whether, okay, are we going to find that this is an exception to the learned intermediary doctrine if people want to say, I was vaccinated in one of those mass clinics, and there's some liability on that basis. Next slide, please. So let's talk about the COVID-19 vaccines. As Special Master Corcoran mentioned, these are not covered by the National Vaccine Injury Compensation Program, but that doesn't mean that you can run to civil court and file a claim, because there's a separate program that covers these, the Countermeasures Injury Compensation Program, which is a program that comes into play when there is specifically a declared emergency. And there are different government agencies that have the power to declare an emergency. In this case, the Secretary of HHS in February of 2020 invoked the Public Readiness and Emergency Preparedness Act and laid out something. And that was before we had any vaccines for COVID. It basically said anything that is a medical countermeasure that appears more likely to help than to harm in treating COVID is going to be covered by this program and is therefore immunized from liability. The manufacturer, distributors, insurers, administrating physicians, pharmacists, or other persons are all immune from liability for an injury asserted to be caused by that product. And that liability is very broad. There are cases where someone has gone to the pharmacy to get a vaccination and they slipped and fell in the parking lot on the way in, but because they were there going to get a vaccination, they're covered by the Countermeasures Injury Compensation Program. There are a lot of cases now, but early on, this is a 2012 case from before COVID, where we had a school official who administered an H1N1 vaccine to a child without parental consent, and that was held to be covered and immunized through the Countermeasures Injury Compensation Program, or through the PrEP Act. The program is for compensation for the injury. The PrEP Act provides the coverage. And the Stormont v. Walgreens case is a similar case that has come up during COVID times. What happens if a child is immunized without parental if you have an injury that is caused by it, it's a covered vaccine. Next slide. So the CICP, I sort of basically said this. It covers all of these products, and all these people are immune from liability absent willful misconduct. You have to be able to demonstrate willful misconduct. And in the Walgreens case, this is they vaccinated a child without parental consent. That's willful misconduct, and that was found not to be within the understanding of the program. Next slide, please. So here's the juice that I want to get to. CICP has some significant differences from the NVICP. NVICP has much longer statute of limitations. For the CICP, you have to file your claim within 1 year from the date the vaccine was administered. So it doesn't matter when the first symptom manifested. It doesn't matter if 2 years later you die when you assert that was caused by the vaccine. You have 1 year to file from the date of administration. Compensation is for serious physical injury. That is ill-defined. The CICP, by the way, also covers, for example, if you have an anaphylactic reaction to a vaccination and then you're administered epinephrine and you're injured by the epinephrine, it covers that epinephrine administration also. There are no judges, there are no special masters, there's no judicial review that is provided for. It's not an adversary proceeding. Claims are basically, it's like a Social Security adjustment claim. You file a piece of paper saying, I received this vaccination, I was injured, here's all my evidence, and it is reviewed by someone in purely a functionary manner. And if you don't like the outcome of that, you can ask to have their supervisor look at it. But there's nothing beyond that, and there's really no place for lawyers in the process. And it is my understanding that out of several thousand claims that have been filed asserting COVID-19 vaccine injuries, there have been about a dozen that have been compensated. So it is both a very opaque program and one that does not seem to be turning anything out. Next slide, please. So the PrEP Act invocation for COVID vaccines has been extended to December 2024. So end of December 2024, on paper at least, that expires, and then we don't know what happens next. And there are four possibilities. It could be that nothing happens, that nothing gets done by that time, at which point anyone who's injured by a COVID-19 vaccine would just be able to go to civil court. There would be nothing preventing that liability. And that's the same thing you would do if you were assertedly injured by a yellow fever vaccination or shingles vaccination. We have class action litigation going on for shingles, or another vaccine that is outside the ambit of the NYCBA. PrEP Act immunity could be extended further by the executive branch. They can basically do that forever. There certainly is still a pandemic ongoing by the usual measures of public health. So, you know, that is another possibility. And if nothing else happens, I think that's likely. The COVID vaccines could get moved to the NYCBA by the Secretary of HHS. Now, you'd have to have the process by which other vaccines are recommended for children and then being recommended for children. Secretary of HHS amends the table pursuant to notice of comment proceeding. If that happens, there's going to be some complication from it because there are 8 special masters, and that is the limit by statute, and they'll have additional cases beyond the very heavy caseload they already have. And it should also be noted that until the PrEP Act expired, which is the end of December of this year, any vaccines administered at that point would be covered by that. So if you know, on January 1st, you say, well, I got vaccinated yesterday and I was injured, you would still be out of luck. That would still be covered by the PrEP Act indication and fall into CICP. Next slide, please. And I have to hurry through the rest of this. So I'm going to be very quick with this. Workers' comp does cover some vaccine injuries. If you are an employer and your employee and your employer requires you to be vaccinated, there are some interesting twists to that. But I think you have my slides. You can see what I said. You know, it may even be the case if the government has imposed that the employer have employees mandated, if that's for the benefit of the employer. Next slide. And then finally, as mentioned, if it's not something covered by on the vaccine injury table, covered by the NYCBA, or covered by a PrEP Act indication under the CICP, then there's no immunity, and then you can just go to court. So, you know, again, yellow fever vaccine or tuberculosis vaccine or things of that sort. If you're a foreign national and you receive a U.S.-made vaccine in another country, even if it is an NYCBA covered vaccine, you can come here and file civil court. Foreign nationals receiving it in other countries aren't. And if you're a military personnel and you receive a vaccine in the course of your military service, you can go to veterans claims. You're not precluded from doing that. And that's my presentation. So thank you very much. We'll move on to the next speaker.
Yeah, thank you very much, Professor Abramson. And now I'd like to invite Attorney Jennifer Allen.
Hello. So I think the big question is COVID and the VICP and where we go from here. I think this has been an obvious concern for a lot of people, whether that be the courts, the government, the general public, attorneys, everybody. You know, we've always kind of had this just feeling of what are we doing and where are we going? So that's kind of what I want to talk about. Can we go to the next slide? Okay. So it's important to understand the differences in the branch of government. There are different rules for who is impacting the way that things are done. And so there was the executive branch that was giving the state of emergency. And that state of emergency allowed them a lot of opportunity to make a lot of rules, do a lot of things, take action to try to save our lives, frankly, is what they were trying to do. Because we were in a catastrophic situation where we had this terrible virus. But the state of emergency ended over a year ago. And we've had a lot of transition publicly, politically, all kinds of things going on. And so the question is, what are we doing now that the state of emergency is over and we're no longer referring to it as a pandemic, but an endemic? So I think the transition first comes from the Countermeasure Injury Compensation Program. That is certainly an emergency program for people that are injured by emergency measures taken by the federal government to protect your safety, your livelihood, your health, all those types of things. But it doesn't give you all of the benefits that you would normally receive from the vaccine injury compensation program. For example, they don't allow you to have attorneys that are paid for, and most people that are filing into that program can't afford attorneys. They aren't allowing a lot of benefits and that would be given normally, which would be a pain and suffering award. It basically gives you the bare minimum to survive. So the question is, if the emergency is over, why is it still the bare minimum? So if we can go to the next slide. How do new vaccines get added to the injury table? Because that's really what we need to have happen here, first of all, right? So to accomplish this under existing law, the CDC has to recommend the vaccine for routine administration to children and or pregnant women. That happened in 2023. So we know that that has been met. The next thing that has to happen is Congress must enact legislation to apply the excise tax to the vaccine. That has not happened. And I think there's a lot of complicated reasons that that hasn't happened, which I'm going to get to later. One of them being that we have gone through a different set of administrations. We have a very hostile election coming up, and all of this is political at the end of the day. So we'll get to that, why that hasn't happened. But the third step is that the Secretary of Health and Human Services has to add the vaccine to the vaccine injury table. Obviously, that hasn't happened because if it has not been, if there's no excise tax, there's no ability for them to add it. Okay, next slide. So, the recommendation of the vaccine for pregnant women and children triggered a statutory obligation for the Secretary of HHS. So that's why they have to deal with this. They have to think about it. They have to figure out what they're doing. But it doesn't necessarily mean that it's going to become a covered vaccine or it's going to hit the injury table. It may be a vaccine that is covered but doesn't have necessary injuries that hit the table. There's a lot of complications that go along with it. So from my point of view, I think Congress needs to act. They need to apply the excise tax. They need to either change the rules for the state of emergency, add the COVID-19 vaccine to the vaccine injury table, or increase the excise tax to support the fact that we're going to have to deal with these claims. But they haven't done any of those things. And I think that a lot of that is dependent on the upcoming election and really what's going on politically, unfortunately. Okay, next slide. So the problems anticipated. If the COVID-19 vaccines are suddenly covered by the VICP, and they just say, you know what, we're going to give you that backlog, that 6 to 8 year backlog, and we're going to cover it and we're going to pay for it, and it's file all these claims. So obviously you can file with the court within 2 years of the vaccine being added to the table, as long as the injury has occurred within 8 years of that table update. So you potentially have a huge backlog of cases when the government finally makes a decision about how they're going to handle this. Okay, next slide. So the VICP is capped at 8 special masters at this point who adjudicate cases. There's limited Department of Justice resources to litigate the petitions. There's also less than 400 petitioners counseled currently barred in this court. The problem there is, I think what the special master was getting at, nobody anticipated this exploding the way it did, the cases increasing exponentially the way that they did, or having to fund this program the way that it needs to be funded. But the reality is that if all of these cases suddenly hit the VICP, there just are not the resources to deal with this. And so the only answer is going to be that Congress would have to act in a way that they would not only allow these cases to come forward, but they would also have to fund additional resources for the court, petitioners council, everybody involved to handle this. I myself, as a petitioner counsel, dealt with, I would say, close to 40 phone calls a day for 3 years of people that were being compelled to get the COVID vaccine. No attorney, no law firm is equipped to handle that during this type of pandemic. And there were no resources to really figure out what we were supposed to do with all of that. And I think that this is becoming a bigger problem as time goes on, because the longer the government waits to act, the bigger the problem gets. Okay, next slide. There's an alternative. So the alternative is a combined vaccine. On June 10th, 2024, Moderna released an announcement that its phase 3 trial of mRNA-1083, a combination vaccine against influenza and COVID-19, has met its primary endpoints, eliciting a higher immune response than the licensed comparator vaccines used in the trial. So this goes back to what we were talking about with H1N1, which is that when swine flu hit, we immediately combined that with influenza vaccines, and people were just getting it. But this has become a much bigger political issue. So now we're looking at a combined vaccine. What does that mean for the court? Okay, next slide. So if they approve the Moderna vaccine for 2025, it would mean no prior COVID-19 vaccine claims are covered. That would be great for the court and the government. It would alleviate a huge burden, because if you didn't file with the countermeasure program at that point, then you're not entitled to file with the VICP at this point. They wouldn't have to allocate additional resources to the VICP or attorneys or anybody for that matter. So it benefits Congress in a certain way. It's a minimal additional public risk. So it's one shot instead of two. You're getting the flu shot and COVID together. So you're having less injury reactions. There's no need for additional funding allocation. The vaccine would be taxed through the seasonal influenza vaccine. One shot reduces the risk of asymptomatic carriers, seniors forgetting to get vaccinated. Studies suggest it may elicit a stronger immune response, but this leaves us with the big problem that if you combine these vaccines and Congress does nothing for additional funding to the court, to the judges, to the attorneys that are representing these people, to any of the people involved in this program, when you combine those, if the symptomology increases, if the reaction increases, now you have thousands of claims coming in with no additional resources because it's under the guise of that same influenza flu shot. I mean, when you walk into a CVS and they say, do you want your flu shot? Do you know that it's influenza A, influenza B, and H1N1? And are you going to know that it's influenza A, influenza B, H1N1, and COVID? Probably not. And the court doesn't differentiate. So what that means is that as soon as you get that shot, if you have any of the covered reactions, it's automatically going to hit this program with no additional resources. And I think that's a huge problem. So I guess I gave you more questions than answers, but
Thank you, Jennifer, for addressing this very important topic. And up next, we have attorney Jessica Wallace. Jessica, I think you are still muted. Let me try to unmute you.
Okay. Can you hear me?
Yes, we can hear you.
Okay. I just want to make sure that you can see the right screen.
So right now we do not see any slides.
I'm going to share it right now.
Okay, we can see them.
All right. So I might present some overlap of what we've heard, but I think I have some new information or some different information. I kind of focus a little bit more on what this looks like from a petitioner's perspective and from an attorney that represents petitioners in the vaccine injury program. So just, when we get a call, these are really complex cases, I'll say too, and especially with the different vaccines that are being given, some that are covered, some that aren't covered. It's very important to really do a really thorough intake, and I'll get to that later. But one of the first things that I would ask somebody who is, calling about being injured by a vaccine is whether or not they've reported the symptoms to their medical provider, whether they've sought medical evaluation or treatment for the injury that they're alleging or the symptoms they're alleging, and also advise them of the vaccine adverse events reporting system, because that is the National Safety Surveillance Program. It's administered by the FDA and CDC to collect the data and analyze the data regarding the adverse events following vaccination. If a person, a VAERS report is also can be used or submitted as evidence, not just positive evidence, but it's just submitted as documentation. It can be in your vaccine injury compensation case. So typically, medical providers would be the ones to report it, or it's better to have a medical provider report if they think there's an adverse reaction, but there's no limitation on who can report. So if a person believes that they've had an adverse reaction, they can report it if their physician won't report it. Also making just to put it out there, making a false report to VAERS is a violation of the federal law. So it's important to let people know that as well. When talking to people who the potential clients who believe that they've been injured by a vaccine or have a serious injury after vaccination, it's really important to conduct a thorough intake. You got to ask a lot about any and all recently administered vaccinations. I think one of the things that we find is that people tend to focus on vaccines if they have several, within a time frame close together. They tend to focus on the vaccine that they are not familiar with. So sometimes we would get calls from people and they would be saying they were injured by the COVID vaccine. But when you really got down to the bottom of it and started asking them about if they received any other vaccines and getting the vaccine administration record or records and analyzing that, it may not have been the vaccine that they thought it was, or they may have thought they got this certain vaccine, but it was really a different vaccine. So very important to kind of conduct that really thorough intake and really understand the different types of vaccines that they may have received or which individual vaccine they could have received, because as we heard previously, there are certain vaccines that there could be two different formulations. So the pneumococcal vaccine, for example, there's one that's covered and one that's not covered, and adults do get both of those. So an adult might get a PPSV 23 that's not covered, or they might get a a PCV20, which is a covered vaccine, or a PCV13. So really important to get the details and really understand the different vaccines that are covered, aren't covered, and which vaccines the potential client may have received. Again, asking about if they've had any other vaccinations in the weeks or months prior to or after the vaccine. And for several years now, we've had certain vaccines that are given together. You know, COVID and flu vaccines are given simultaneously since probably about 2021. So digging into that vaccine record is going to be really important. When you're analyzing these types of cases, obtaining and reviewing the medical records is critical. And so you want to get all, you know, pre-vaccine records and post-vaccine records, and dig really deep into the medical records, looking for the, you know, what they'll obviously tell you what they believe happened to them. But, you know, take that and then go into their medical records and really dig down to make sure that what they're telling you is, you know, that the medical records kind of follow what they're saying. Chief Special Master Corcoran also discussed how the onset of symptoms is very important, and you can have an onset that's too soon or an onset that's too far out from the time that the person received the vaccine. So again, important to really dig into the medical records and look and see, when do those symptoms start to come up, and is what the client is telling you or the potential client is telling you, are the medical records consistent with that? Now, we heard about the two different programs. We heard about the BICP and the CICP, and how the BICP deals with a lot of the routine vaccines we're familiar with, the flu vaccine or a Tdap vaccine or a meningococcal vaccine. And then the CICP deals with the COVID vaccines and some other vaccines as well. But looking at COVID, that's where those cases would go. If your client has received multiple vaccines and it's unclear which vaccine might have caused the injury and which program they should file in, I mean, really, HRSA has a very good chart that discusses the differences between the two programs. And so, you know, I would suggest looking at the differences in the programs and seeing which one might be the appropriate program for your potential client. However, as we've heard, the CICP is not really a program that allows for, well, there are no attorney's fees allowed, or the program itself doesn't pay the attorney's fees as it does in BICP. So there's, I don't believe there's very many CICP petitioners or claimants that are represented by counsel. For either one of these programs, the BICP or the CICP, medical records are going to be key. You're going to want to get, as you know, many types of records as are available, and there are certain requirements. There's different requirements in the different programs. So for the BICP, we usually go about 3 years back. If it's a child, then you want to even go and get the birth records or the OBGYN records. So other records, as we heard, can be admissible too as evidence that'll be looked at. It could be educational records, employee records that might show a time period where the employee wasn't at work, or CPS records maybe. And in death cases, the autopsy files are very important, and not just the autopsy report, but also the autopsy photos and, you know, recuts of slides that can be sent to an expert to review. So medical records are definitely something to focus on. We heard about the different statute of limitations from some of the other panelists here, but just really quickly, for the VICP, you're going to have you have 3 years from the first symptom, from the onset of the first symptom. So that is for the VICP. And then in a death case, it would be 2 years from the date of death. The difference for the CICP is that it's 1 year from the date the COVID vaccine was received, and that's it. So one year from the date it was administered, and that's it. That would be for an injury or a death. Just as a visual, we heard about how the VICP cases kind of move through the courts, but just visually, you know, this will kind of show you that we start in the Office of Special Masters, and first level of appeal would then go to, if either the petitioner or the respondent is not satisfied with the decision, you can appeal it to, or do a motion for review to the U.S. Court of Federal Claims. From there, you would go to the United States Court of Appeals for the Federal Circuit and limited cases have gone up to the United States Supreme Court. For the CICP claims, it is an administrative type review. So there's a specific claim form for benefits that's on the CICP website, and a claimant would have to complete the claim form, and it's required that there are medical records submitted. However, a claimant does not have to submit the medical records at the same time. What is the most important is that the claim form for benefits is filed by that 1 year from the date of administration, and then the other documentation like the medical records or authorizations that have to go to the providers can be submitted later on. Once a claimant puts in their request for benefits package and puts in the supporting documentation, it goes to a review by the CICP medical staff, who reviews it, makes the decision, and as we heard, if you're ineligible or found to be ineligible, the only recourse really is to submit a letter of requesting reconsideration of the decision, but it goes basically back to the same panel. So this is something that I think is some new information here, is some data on the BICP and how many cases have been filed and adjudicated, and kind of looks at some of the costs that the program has incurred and what it's paid out. So while there's been 27,618 cases filed, this is again as of August 1st in the BICP since 1988. It's paid out 4.7 billion to petitioners. Then of course there's also attorneys' fees and costs that have been paid out. And here you can see the attorneys' fees and costs that were paid out on the dismissed claims, and the total outlays for the program as of 2024. Interestingly, so we can see here when you look at the last few years as to the trends, it pretty much the number of cases per year is somewhere around 1,000 cases a year that are being filed into the vaccine injury compensation program. So looking at the CICP data, the CICP, the full data or the total amount of claims goes from 2010 to 2024. So prior to COVID, there was the H1N1, the 2009 H1N1 pandemic. There were vaccines that were vaccines and countermeasures, but I think mostly the vaccine that was incorporated into the total number here. And it also includes some claims now where there's some claims that have been made for monkeypox, and there's some older claims for anthrax, and it also includes other COVID countermeasures as well. Out of the total number of COVID-19 claims or countermeasures related to the COVID-19 pandemic, 10,000 of those, over 10,000 of those are alleged to be injuries from the COVID-19 vaccines. And the number actually may be higher because there's the remaining 3,000 cases, or about 3,000 cases here, and some of them might include cases where it's unclear where it's from the vaccine, but if we can just figure that it's about 10,000 of those claims. So the majority of those claims are alleging injuries or deaths from the COVID-19 vaccine. Currently, there's about 10,000 cases pending for review in the CICP. And they're not really moving too fast there. There's also a much higher standard of proof. So where Chief Special Master was talking about the standard of proof in BICP being a preponderance of the evidence or a 50% and a feather, in CICP there's a much higher standard of proof, and it has to be based on basically direct proof that the vaccine caused the injury. And we'll see kind of in a bit here what they're using to kind of look at whether there's causation or whether there could be causation, and what kind of claims they're compensating at the moment in the CICP. So as far as the COVID-19 claims that have been eligible for compensation, there's been 57 claims eligible for compensation. All of them are related to the COVID-19 vaccine, and 14 of them have been compensated so far. And then because this program doesn't pay for pain and suffering, or doesn't compensate for pain and suffering, the only benefits that you could get from this program are out-of-pocket medical expenses, lost wages, or in the case of a death, there's a death benefit that's around 300. It was a couple of years ago, I think it was about 370,000. As far as COVID-19 claims that have been denied, there's been over 3,000 claims that have been denied. And the different reasons that they could be denied is that the individual did not submit the requested or the required records, or they didn't meet the standard of proof, and or they missed the filing deadline because, you know, again, 1 year from the date, many people didn't know about the program. And so I think that was really one of the frustrations that injured, you know, claimants or petitioners would really have when they would call and then be told that, you know, they couldn't do anything because they were past the very short 1 year statute of limitations. Here's some CICP data related to the amount of compensation that's been paid out. So in looking at this, you know, it's hard to tell. We don't know exactly what it's for. I would assume that this one here is a death because, as I mentioned, the death benefit, there's a certain calculation and fixed amount, and this one looks like it was probably a death. As far as the other amounts, you know, again, we don't really know whether those are for lost wages or out-of-pocket expenses, but they're all relatively low amounts here. And if you look at the types of injuries that were compensated, they're pretty much in line with what the CDC has recognized as far as being you know, injuries that could be possibly related. So they're kind of limited in scope of injury, where BICP is a bit different and has, you know, numerous different injuries that have been compensated through that program. So these are the injuries that actually have been either compensated, or some of the ones that you didn't see on the list before. These reactions or these adverse reactions, they've been determined to be compensated, but the amount of compensation hasn't been determined yet. So that's why they weren't on the last chart. And again, so recently, over the last year or so, there, I guess probably 6 months or so, there was a report that came out after regarding. So the National Academies was basically a committee convened to look at whether the COVID vaccines, whether there was causation for certain types of injuries. And so there's some limitations though to this, to what they looked at and how they determined these, because a lot of the data that they used was really from the primary series of the vaccines that came out. I would say that probably it didn't include a lot of children, since children were later on in the list too. It's actually in the document itself, you know, it says that is kind of a limitation, since children were later on to receive the vaccine. And this study was kind of started, you know, shortly after the vaccine program, the COVID-19 program started. So the data that they were using isn't really comprehensive. They also didn't look at, you know, back in 2021 when they started administering the different vaccines like the COVID and flu vaccine, they weren't looking at that either. They were looking at just the COVID vaccine. So and these are the adverse reactions that they found to have some kind of a causation, or that they thought that there could be causation. So these are the ones that we're seeing paid. This one actually is not on the list, the severe febrile reaction, but this one got paid. So as far as whether or not you would need an attorney in VICP, it's not required in either program, but it would be highly recommended for a claimant or for a petitioner in the VICP to have an attorney. There are legal proceedings. They are the respondent in these cases is the Department of Health and Human Services, and they're represented by the Department of Justice attorneys. So it's litigation, and it would really behoove the petitioners to have an attorney who understands the workings of the program and the standards, and also what's required, because the literature, you know, improving the Alton prongs that the Chief Special Master had mentioned earlier. It's not just about saying I got a vaccine and I had a reaction, and so, you know, and anybody can see that, and I can see that, and I wasn't sick before. You actually have to go into the biological mechanisms and the immunology or the neurology or whatever system you're looking at, and get into the science. So it's a good idea for petitioners to have attorneys. The program does allow, as we heard, for attorney's fees. So you know, the petitioner does not have to pay for attorney's fees, and the attorney's fees do not come out of any award that they would receive. As far as the CICP, there's no similar fund or rules regarding attorney's fees. So most claimants, I would say, in that program do not have an attorney. And let's see if there's anything else. This chart was taken from the Health Resources Administration website, and it's a really good comparison of the differences between the two programs. A lot of what you heard today is probably summarized within this chart. And I don't know, I don't know where I am on time, but that is my presentation for today.
Thank you. Thank you, Jessica, and all our speakers for your fantastic presentations. And now we move on to the Q&A session. We have received several questions from the audience, and I see that some of them are related to the last presentation. So I'll just start with them. So the question related to Jessica's presentation is, 1 second. How many cases does the court manage every year, and what is the average of standard compensation awarded?
I think that one's really more for for the chief special master, but he was saying that I heard in his presentation it looked like there's about 3,500 active cases at the moment. So you know, and again, if we look at the data that I had up with the chart, I would say it's as how many cases are filed each year. It's about 1,000 cases looks like it's filed each year. And average compensation, I think it's really hard to say. It's going to be, each case is different. Every case is different. You can have a petitioner with the same injury, but it's going to be different based on what their circumstances were, how much medical care did they receive, how long were they suffering, how severe was their pain. So I don't think you can really give an average amount.
I'll just add as an example, a very minor injury like a skin abscess, for example. I have a bunch of cases that are related involving skin abscess injuries that several people received at a mobile vaccination unit in Kentucky. And those will probably pay $10,000 to $15,000. You know, that's just a very easily treatable injury, and there's very minor pain and suffering compared to a catastrophic injury involving a child who may the rest of their life be quadriplegic or have mental disability due to brain injury. They might get, they'll get the full pain and suffering award, which is capped at $250,000. They'll get all of their medical expenses. They may have an extensive life care plan, and often the first payout for a case like that is $1 to $2 million, and the government typically enters into an annuity contract that will spin out enough money every year for the child's life to care for him. So it really depends on the extent of the injury.
Thank you. And I'm glad that you mentioned child, because I saw there was a question about, give me 1 second, I'll find this. Okay, do either of the programs include coverage for injuries to live-born children? How about miscarriages?
Well, I can say that, I don't recall exactly, but I've had a couple of cases where there was a question about whether the child was live born. And if it is, then a claim can be brought on behalf of a child under certain circumstances. I think injuries in utero where the child doesn't survive are probably only attributable to the injured mother, and she would be limited in the claim, but she couldn't bring a claim on behalf of her child. That's the way the law construes the difference between live born and a child that doesn't come out alive.
Oh, thank you. I'm curious if both a child and a mother are injured, could they both apply, I would assume?
Yes, as I just said, if a mother received a vaccine and then she gave birth, and her allegation was that she was harmed by it, and that the child was as well, and you could show separate harm, then yes, both could bring a claim. You cannot claim pain and suffering for an injured party that is not you. So, for example, in a case where a child is injured, let's say it's just a 3-year-old, for example, the parents and the family may suffer tremendously from having to care for the child, and they may, we see really, really tragic situations in our court, a lot of tears, and they're real people who have been hurt, but they don't get to assert their own claim for pain and suffering. So only the child, the child's pain and suffering is what is estimated in a case like that.
All right, thank you. I have several questions related to the process and to the court specifically. The first question I see, how long does the litigation process typically take from filing a petition to receiving a judgment?
Well, I'll answer. Some of the practitioners might have some insight on that, but I can say it really depends on the nature of the claim. Cases that we want to settle, like that go into the SPU, like shoulder injury cases, SERVAs, they could, in theory, I'd like to resolve them within a year. I mean, my goal is to get money to the hands of deserving petitioners as quickly as possible. But they often bog down the way litigation bogs down. There may be some issues of the records, or there may be a disputed issue. I would say the fastest we ever do is maybe 2 years. And in a really complex case, by contrast, where damages are very intricate and there's entitlement issues, and there may be an appeal or two, we can be looking at 5 to 10 years. But the thing that I most am concerned with as the Chief Special Master is making the process not only transparent and efficient, but fast. I mean, that's what I'm called to do under the Act, and we're always looking for ways to expedite. But we have to do it in a way that's fair to the parties. And, a lot of times, sometimes I find myself trying to push cases too quickly, and the claimants are like, whoa, 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 we want X, we want Y, we want Z, we need more experts. And so they are often to blame as well for slowing the case down, because they believe it's in the interest of their client. But yeah, I mean, it really varies by claim.
Okay, thank you. And also a question related to the procedure. Are hearings conducted in person or through virtual means?
Well, so the vaccine program is within the Court of Federal Claims. We didn't really talk too much about the court, but the court is an Article I court created by Congress, and it has nationwide jurisdiction, as do we. So we have petitioners from all across the United States. Ms. Wallace knows she probably gets clients from everywhere who will call her up, and they'll want her to represent them in our court in DC. And we often travel for our cases. We go where the petitioners are if they ask us to. Now, in the world of COVID and Zoom, and we're here tonight in the world of Zoom, right? I find more and more that litigants actually say, we want to do a Zoom trial. And a lot of times, most of the parties or number of the experts will testify remotely. I always try to get people into my court or agree to go where they are. I find that I can do my job best if I actually have live human beings in front of me rather than, talking heads. But we aim to please. And I often have a case where I'll have the lawyers before me in Washington. I'll have the petitioner and his or her family who need to testify there in one place. I might have experts in a whole nother place. So it's a variety, but these days we have been doing less traveling than we used to. We used to be on the road a lot, but I think because of the advent of technology and Zoom, it's made it easier to have these kind of hearings. And I think maybe the practitioners can comment, but I think that they sometimes appreciate that.
I just thought to kind of tag on to what the Chief Special Master is saying. I think when you have experts, especially, it's very helpful to be able to do it over Zoom, because when you're trying to coordinate with experts who have clinical practices and are very busy, and it's also, I think, helpful to the resources of the program to conserve some of the resources of the program as best you can, instead of having to, because the program pays for the cost of the litigation if they're reasonable. And so if you're going to be bringing 3 experts to Washington, and they have the hotel and this and that, and all of that goes into comes out of the program. So I think for that, it's helpful and beneficial. And also, again, to kind of coordinate it if you have multiple experts on your side, respondent side, and kind of get everybody together. That was my take. That's my take on it.
Yeah, thanks. I'm moving on to the next question, but also related to the procedure. It's probably more relevant to the litigators, Jennifer and Jessica. Is it difficult to obtain expert testimony or reports for these cases? And the follow-up, I guess, question, do doctors tend to be hesitant to offer their expert opinions in court?
Jessica, do you want to start or do you want me to go first? I'll start. I have found that treating doctors, if they're not familiar with the program and they're not familiar with the fact that it's a no tort kind of scheme system where they're not actually going to be named, that if a client has been injured by a doctor, they tend to be reluctant to admit that has happened, that their nurse has injured them, or that anything has happened, because they're a little fearful. I have only had one case where I had a treating doctor actually say, hey, if you had an adverse reaction to this vaccine, here's a pamphlet. This is the court you can go to. Every other person, it has been years after where their doctors and nurses didn't want to admit to any culpability. And I think that that's a huge problem. And I think that it has gotten worse with the COVID pandemic, because what we did is we rolled out all of these issues where you have nursing students and untrained people administering these vaccines, and that's starting to cause a lot more of what Judge Corcoran was talking about, which is the server problems. And so my experience is that doctors tend to be a little reluctant to offer up information about it, and finding any doctor that feels confident testifying as an expert is a little bit difficult. They usually have to be very proficient in vaccine complications, those types of things. You can't just hire your run-of-the-mill, orthopedic doctor or neurologist. It has to be a doctor that really knows about this type of injury. So yeah, I think there is some difficulty in finding those experts, which puts people at a disadvantage for self-representing.
Yeah, I think you end up getting a lot of repeat players where you have the same sort of set of people who are experts and they testify in a lot of different proceedings. But someone can correct me if I'm wrong about that. That's the sense I get from reading the cases.
Yeah, I mean, I would agree. It's difficult to find even some of the experts. I do think it's difficult to find experts that will come out and do this kind of expert work, but also because it's not. I think it's different. I mean, I don't do personal injury, but from what I've heard of or know of personal injury, this is really complex. The experts have to really know the medical literature. Like the science. Again, you're getting into immunology, neurology, rheumatology, and how these, at the molecular and cellular levels. And so it's not just like you need.
The reality is that in a lot of personal injury cases, doctors give just run-of-the-mill opinions on every case. This is not that kind of work. This is actual expert doctor work. They need to know it inside and out. They need to have a good knowledge base. They need to be able to support their opinion. And what I have found is, yeah, a lot of doctors are reluctant to do it. It's difficult to find experts in this field.
And I have to just jump in and say, unfortunately, their typical hourly rates sometimes are a lot higher than what's allowed in the program. And so that does make it challenging that's just a reality that the petitioner's attorneys face, I think, so.
I agree. I have had to pay almost double what I can actually bill for to get an expert opinion. Because they already recognize that they have a huge risk of their opinion being public, they may be being called to testify. And so compared to other cases, I have found that experts in this field charge a lot more than any other experts.
Oh, thank you. And Jennifer, I just have a follow-up question about it because it's basically it was not clear for me. So who will be covering the expert fees? Are they covered by the program or they're separate? Maybe it was mentioned and I missed it in your presentation, but
No, sure, I can answer that. So I would pay the expert fees out of pocket, but then you submit it to the court, and then the court refunds those fees. But they also determine whether it was a fair fee or not. Just like when you submit to the court your billing for your attorney hours, they determine whether or not that was an appropriate amount of time that you spent, what you were actually doing with your time, and what you billed. So when she's saying sometimes we have to pay more than the court's willing to pay, what she means is sometimes we have to pay them more than what the court reimburses us for. And we get reimbursed at the end of the claim. Well, we can submit intermittent fees, but yeah.
But I was also saying that, you know, sometimes the experts' fees, well, their experts' hourly rate, yeah, I mean, I guess is more than what the court would award, you know. So
Right.
if you don't want to pay more, you know, if you don't want to have to come out of pocket and pay it, then you may lose the expert, you know. So it is just the reality of where we're at with our experts at the moment. Some of them, not all of them.
Yeah, I mean, you just have to decide if this is the doctor I want, I know I'm going to eat half his fee because the court isn't going to reimburse me at this rate, but this is who I need. And yeah, it's a problem that we face.
But there's been progress a little bit.
There has been. It's been getting, I will say in the last year, it's been getting better. During the pandemic, it was awful. The last year, I feel like it's been getting better, but yeah.
Okay, thank you. And another question that we actually discussed within committee about the opinions. Are those opinions, you mentioned that they're going public. Are those cases public? Are they available on Pacer or anywhere, or it's kind of sealed record?
No, once we issue a decision in a case, like for entitlement, let's say, and you know, we want the public to know what we rule. We want them to know either that yes, this is an instance where someone was injured, or no, this is not a viable theory and it's not something people should worry about. They are available on Westlaw and they can be accessed. And then, you know, there's the government automatically is publishing up as well independently our decisions too. We will redact the names of the litigants upon request if a certain standard is met. So like children's names are automatically redacted to their initials. But if a petitioner makes the case that, oh, I work in the medical field and it would be damaging to my career if this claim was published to the world, we'll address that and redact that as well.
All right, thank you. I'm going to move to a next question, and we only have about 2 minutes left. So what is the biggest challenge for petitioners in establishing causation for injuries, alleged from the COVID vaccines?
The research isn't there yet.
Yeah, it's science. It's not ready. Yeah.
Because the standard is so high. So currently in the CICP, you have to have direct proof of a reliable scientific, theory that, and so it's very high. So that's why you're only seeing those certain claims being paid that, basically the CDC is recognizing, and if that as being causal or potentially causal. I mean, so the standard is just really high.
Yeah, Jessica, I tell my client, like when people call in all the time, I say to them, you have to recognize the law has to catch up to the science, and the science isn't even there yet. They expect there to be this immediate legal reaction, but the science isn't even there yet to fully prove it. And I think that this vaccine becoming a political issue has convoluted the point that there's a process and that just we haven't quite gotten there.
And also the standard, you know, because even if you were to take those COVID injuries and put them into VICP, I mean, a lot of these people that think like, that's it, I could show you right now, I am injured, I was healthy before, and everything went bad after that. Like, even if those people that really truly believe that, you know, nobody could see it any different, it could, you know, you have to prove it still. And I think that's where there's a disconnect, you know, that's the hardest thing, I think, for clients.
The hardest thing to explain to clients is, I get that you think that's what happened, but that's not what the doctors said. And that's hard, you know. But yeah, so I think that's kind of what you were getting at, is that you have people that had other issues going on. They got the COVID vaccine, and because of the political issues surrounding it, they assumed it was related to that rather than other things. But
I mean, I'm just saying people that called, you know, and would say like that's what they would say, you know, and so they would think that they had like the best case, but it's, you know,
yeah,
you can't. It's a lot more than that. It takes, you know, it takes a lot more. You have to have the science to back up what you're trying to prove.
yeah.
Yeah, it's 8:02 right now. We're a little over time, and I guess I apologize for that we haven't covered all questions, because I see there are more questions in the chat that we can answer, but we unfortunately out of time. We come to the conclusion to our webinar, and I want to say big thank you to all panelists for your contribution, for your insight, for your time, and I hope, well, and thank audience for participating. Thank you for your questions, and I hope we'll see you again in the future.
Do you want us to respond to the written questions or no?
I'm not sure if we have time to respond, if you want to respond directly to them. And I just want to address one question that was mentioned about materials. We'll contact the customer service to make sure you will receive the materials we email.
Yeah, by all means, if anyone wants to contact me by email and ask me questions, and surely the attorneys who are practitioners probably, although it sounds like they're very busy with a lot of people who have more than just questions but have claims. But yeah, I'm always happy to do that.
Okay, thank you. I think this concludes our webinar.